Hi, I'm Edward Paranta from PwC's Tax Conflict and Dispute Resolution Unit. In this segment, I'll be taking you through a few ramifications of tax fraud. Existence of fraud over and above the penalties imposed by law has significant ramifications to taxpayers. For one, the Commissioner may issue an assessment against such a taxpayer past the 5-year limit imposed by law. Generally, the Commissioner has powers to issue assessments against taxpayers within a period of 5 years past the date the return for the period in question was filed. However, the 5-year rule may be exceeded where it's shown that the taxpayer was involved in evasion, fraud, gross or willful neglect. Secondly, we have seen in various occasions tax refunds and credits due to taxpayers denied or disallowed or rejected on the basis that they were involved in fraud. In a recent decision, the Tax Appeals Tribunal had an opportunity to express itself on the issue of fraud. In the case, the taxpayer involved had been denied its input VAT claims and an assessment issued for its previous input VAT claims on the basis that it was involved in fraud. You may have heard of the missing trader scheme. In this scheme, it was alleged that traders were involved in mimicking actual supplies for purposes of meeting the legal requirements under the law for benefiting from input VAT claims. This was the basis that the KRA had used to deny the taxpayer in question its input VAT claim as well as for issuing the assessment. In the decision, the Tax Appeals Tribunal noted that the taxpayer in question had discharged its duty of paying output VAT and supplying the corresponding information that he had purchased goods from VAT-registered traders. Not only so, but the traders who are registered in the ETR register. Over and above that, the Tax Appeals Tribunal noted that whereas the burden of proof in tax rests with the taxpayers, where issues of fraud are alleged, the burden shifts to the Commissioner. Not only so, but the burden of proof where issues of fraud are alleged is that of beyond the balance of probabilities. In this case, that burden was not discharged and it was found that the taxpayer in question was entitled to its input VAT claims and that the assessment issued by the taxman was vacated.
Hi, I'm Lynda Muchiri, a tax dispute resolution expert at PwC Kenyan. I'll be highlighting the court's decision in the standard and burden of proof in tax fraud cases. Courts have taken the position that tax fraud is a criminal offense, and a person can only be said to be guilty of tax fraud once they have been charged, tried, and convicted of such an offense. In addition, evidence is a key element in tax fraud cases. The burden of proof in tax fraud cases lies with the party alleging that there was fraud. That party is required to adduce solid evidence proving to the guilt of the person accused of fraud. We have seen instances where tax fraud cases are dismissed for lack of sufficient evidence. In civil matters where tax fraud is alleged, the courts have taken the position that since allegations of fraud are of a serious nature, the standard of proof is higher than the ordinary standard of a balance of probabilities. This principle was relied on by the High Court in a land dispute matter where fraud was alleged, and the fact remained that allegations of fraud should be proved beyond the ordinary standard of a balance of probabilities. This decision can be relied on in tax cases as well.